With the consent of the petitioner, I beg to mention item number 5, my lord. This matter will be taken after 2 weeks, my lord.
My lord, it may come up after 3 weeks so that we can file a reply if necessary, my lord.
Okay, 5.
5, sir.
5, you are also there?
Yes, my lord.
Okay. For respondent number?
Petitioner, I am for the
Petitioner,
Oh,
response.
acha, okay, okay.
I am submitting on behalf of S. Kanungo, my lord.
Oh, acha, okay. Okay. Which is represented on the prayer made by Mr. S. Boral and standing counsel for the
Yes.
CMC list after 3 weeks, by which time the petitioner shall file a affidavit in reply if so advised.
Okay.
May it please your lordship. Lordship, I beg to mention a 439 bail application earlier rejected by my lord for motion tomorrow, my lord. Deeply obliged, my lord.
We have listened. In relation to item number 13, I am on behalf of MS S. Bora, my lord. Let it be next week, my lord. There is a difficulty on her part. She requested me, my lord.
Okay.
13.
13. Okay.
I love it.
On behalf of Ms. S. Boral and counsel for the petitioner, Mr. UK Goswami and counsel for the Inland Council, prays for adjournment. Here is allowed. List after a week as paid for.
May I please your lordship. Lordship, I beg to mention item number 3 and 4 of the daily list, lordship. Lordship, matter may be come out for 2 weeks, lordship.
3 and 4.
Yes, lord.
Just a moment here for something. A week.
After week or 2 weeks, lordship.
After 2 weeks. Okay. Item 3 and 4. Both says are represented on the prayer made by Land Council for the petitioner list after 2 weeks.
Deeply obliged.
Lordship, I am praying for listing of an IA, Lordship, tomorrow, Lordship, along with the main case, Lordship. It's a contempt case, Lordship, that has already been complied. And your Lordship directed for personal appearance of the SIP Secretary, Lordship, just for modification of that. Obliged, Lordship.
Daily list item 1 for admission.
May it please this, madam. Well, this is the matter regarding the fixation of break pay. The matter was being looked after by my colleague D. Chaudhary. But he is suffering from sleep discs for the last 3 days. Therefore, madam, I pray for an adjournment. Yesterday, I have given the adjournment slip also.
Yes, we have received the exam slip.
I appear for 5, 6, and 7. No objection.
Both says are represented on the prayer made by Mr. T. Chakravarti and counsel for the petitioner. List after
2 weeks, lordship.
list after 2 weeks. Okay.
I'm deeply obliged.
Item 2.
Thank you, the Lordship. Lordship, kindly there is the last order dated 12/6/24
Yes,
Here,
any instructions?
here the provisional pension has been receiving, but once it was stopped, after filing this writ petition, the respondent has again started paying the provisional pension. But he is not receiving the regularized pension.
Yes, no affidavit by the respondents. We are allowing this repetition then.
That's my last order, Lordship, the senior colleague, he appeared, Lordship, can it be possible for the timing so that I can inform him?
Because if there is no response, there is no indication of any departmental proceeding or other things. After some time, wait for some time.
Item 6 for admission.
Lordship, in this matter on last occasion, Lordship directed me to produce the record, Lordship. Record has come yesterday late evening when I left the court, Lordship. But they are giving it, Lordship, can it be taken up after, that means day after tomorrow, Lordship?
Lordship, my submission is very limited. Record may be necessary for disclosure of the final case. My submission is very limited in this particular case. I have filed a miss case.
I have also
On the
got the
ground,
instruction,
They have
Lordship.
filed the affidavit also. They have filed an affidavit also. My submission will be, Lordship, in this particular case, petitioner was the inspector of police. Inspector of police. He is investigating a case wherein urea, superphosphate and muriate of potash which is manufactured at Borpeta road in a godown. He has captured altogether 10 LPG trucks, full load of trucks from that person. Thereafter, he started the investigation. And thereafter, Lordship's false allegation was laid that petitioner has demanded to pay some amount from the accused person. And the main accused person has committed suicide by this time. And thereafter, Lordship, this trap has been laid with an allegation that petitioner has demanded some amount. And thereafter, Lordship, 40,000 has been kept in the table of the petitioner when petitioner was eating food, taking food. Thereafter, petitioner came out from his official residence. Then this person kept him where he was going. That's his hand. And thereafter, police come and 40,000 was recovered from his table and he was arrested. That is the main case. But now, Lordship, our case is very limited. Lordship will find the miss case number 1692 of 2024.
Lordship, as I said, Lordship, after the in the miss case also, I have received instruction day before yesterday, Lordship.
You can make submission, Lordship, I am happy to say.
No, Lordship, and this matter can be heard entirely, Lordship. This is not the, nothing the,
Let him conclude his submissions. Let him conclude his submissions.
Lordship.
Lordship, can this is miss case number 1692 of 2024?
Yes.
Lordship will find page 11. Lordship,
Yes.
got it? Petitioner was pending disposal of the inquiry Inspector Ganesh Borman, Simla Baksha, as under substantive effect from involvement of ACPS case number amendment during period of suspension. His headquarters will be Baksha. Will draw the subsistence allowance applicable as per rules. Lordship, got it? This order has been passed on 13 May 2023. Hereafter, Lordship, within 86 days, before 90 days, they have given a choke cause notice, page 12. Lordship. Thereafter, Lordship, the petitioner also submitted his so-called reply. Finding no alter, petitioner has submitted so-called reply, page 16, narrating all the facts. That how trap has been laid, how money has been recovered from his possession. Thereafter, Lordship, inquiry officer has been appointed. And inquiry officer by this time started inquiry and submitted his final report. Submitted his report that charges has been proved. Thereafter, the disciplinary authority set aside this order of inquiry report.
stating that petitioner was not given any opportunity to adduce defense evidence. So his until or finding of the recipient of has been set aside and remanded back to the authority for holding de novo inquiry. Now, Lordship, I will take your Lordship to the order of suspension, review of the suspension. Page 20, Lordship.
Yes, 20 and 21 both.
Lordship. This suspension has been extended. The BND period of limitation, that is 90 days. BND period of 90 days, as decided by the Supreme Court and by this court, that suspension should be reviewed with a revision order within 90 days. Before that, there is an order, Lordship is aware, that if his so-called is not submitted within 90 days, that will be set aside. And that case has been already Supreme Court has held, this court has held, that if suspension is not reviewed within 90 days, it will go. It will not stand. At this stage, that is my stand. And that is admitted position. They have also filed affidavit admitting this said fact that suspension has been reviewed after 90 days. Lordship will
No,
kindly
but
see that affidavit.
Mr. Goswami, everything said and done. By the last order, this court had directed that the records be produced for perusal of the court. But if she has not gone through the records, give her 1 day time to at least go through it. Because we'll.
I have no objection
ultimately-
to that effect. I have no objection to that effect. Whether Lordship will be satisfied on the basis of the affidavit and the documents produced by me regarding my petition,
No, but
case.
once there is a judicial order to call
Yes,
to the
Lordship.
records.
On
you have
last
to go through
occasion,
it.
he also paid the same thing, Lordship, and Lordship directed me to obtain these things, Lordship.
It's okay.
From day one, Lordship, she is objecting by any means, anything, from day one.
No, that's okay. That's one part. But if she's wants to go through the records,
Lordship,
We'll take it up.
I
I'm
have
fully
obtained,
agree with
Lordship,
you.
but
I'm fully
till
agree
now
with
I
Lordship.
have no access to
we'll take
that,
it up tomorrow.
I'm fully agree with you, Lordship.
We'll take it up tomorrow.
Tomorrow, Lordship.
Lordship.
What's
Okay,
the
day after
date?
tomorrow,
Day after.
or at 2, Lordship,
Uh,
if this is convenient, is there
Day after tomorrow, there's a division bench.
Friday?
Uh, Friday is uncertain. Monday then.
No, no, Monday, Lordship, I have to go to Silchar, Lordship. For
No,
admission.
because Friday there's some
At 2, Lordship, today.
difficulty.
At 2, Lordship. Record is there, at 2, Lordship.
Lordship, I have to go through the record because I
Will
have
be
to
here.
appear in other
be
cases
in
too,
court.
Lordship.
So, tomorrow, Lordship.
Tomorrow. Both sides are represented. Mrs. M. Bhattacharjee, learned government advocate, symbols that she had received the records but could not peruse it. And she pays for an adjournment. Prayer is allowed. List on. Make it tomorrow, 17/7/2024.
Obliged, your Lordship.
Daily list, item 7, bail hearing BA.
Matter may be fixed on next week. Matter may be fixed in next week.
Next week. Both sides are represented on the prayer made by Learned Counsel for the petitioner, list on 24/7/2024.
Item 8 for hearing.
I am for respondent number 4, Lordship. Matter relates to appointment of mutable need in work property.
Where is the order of the tribunal? Which page?
Yeah.
Is it page 40?
Yes. Yep. What we did space consulted copy is page 16, 17,
Page?
15, 19. Deed of work is
No. With the order of the tribunal,
order of them,
3010.
Alright.
3011, sorry.
Lord. 59 to
59.
59 to 70 76 Lord.
Who are you? Who are you?
I am for responding to 4 Lord.
Who are you?
I am the temporary mutawalli appointed by the work board.
But your appointment is not in accordance with the Waqf deed.
Yes, Lordship.
Waqf deed says it gives a name, Irshad Hussain Chaudhary.
Yeah.
And therefore, sons and sons.
Right.
Now,
Lordship,
but if you are a third party,
Lordship,
your appointment is illegal.
I am a mutawalli temporarily appointed, but while I was acting as mutawalli, then the work board appointed the petitioner as mutawalli in my place.
Who is the petitioner?
Petitioner is Nurul Islam Chaudhary.
No, name I understand. Name
Yeah.
is nothing. Who is he?
He is the descendant of the Waqif.
So he is
I am
rightly
also-
appointed.
I am also descendant of the Waqif, but there is a condition in the work deed that in case the two persons are found equally qualified, in that event, the senior most may be appointed. But in my case, the petitioner he is a PU, pre-university, while I am LLB. So in that case, my qualification is better than him. And
No,
far-
because Waqf deed doesn't say that. Waqf deed says that if they both the mutawallis are equally efficient and pious,
but
therefore education is nowhere comes in. That's not a qualification.
and
The two conditions are that they should be equally efficient.
efficient.
Yes.
Yes. I am also equally, and I was appointed by the pious Muslim community. And he was selected by some of other descendants.
Where is the proceedings? Where is the proceedings?
Yeah. It's at page annexure 5, page 43, 4, 5, 6, 7. And actual copy is
Just a moment. Please come to page 75, issue number 4.
Lordship. Issue number 4.
CEO of the board asked the candidate to appear for hearing for appointment of Mutawalli. CEO has appointed the petitioner as provisional Mutawalli on 24/1/2013. While petitioner was performing his duty, CEO of the board had appointed Nurul Islam as Mutawalli by order dated so in place of so and so. Now, what is the where is that order?
That order is Annexure 2, page 37.
Page 37.
37, Lordship. Last paragraph.
Yes, and where is the final selection by the for the Mutawalli?
Provisionally appointed as Mutawalli.
Where is the final selection?
Final selection is Annexure 4, page 40, 41. Page 40 and 41. Lordship. In para number 7, the reasoning is given by the board.
Just a moment. Wakaf Act. Does it? Wakaf Act. W.
Lordship, may kindly see section 83, subsection 9 of the work.
May I please, Lordship? Lordship, I'm appearing on behalf of Mr. Anas Mazurbe. He's in Hellore, my lord, for medical treatment, my lord.
You should have circulated. You see, we have started hearing. What prevented you from circulating a adjournment slip yesterday? Unnecessarily, we read the file and then you take an adjournment just like a drop of hat. No, we refuse it. If you don't respect the court, why should the court
Sorry, my lord,
bother
yes.
for you?
Yesterday itself, he has informed about.
No,
it, my
you
lord.
see, he is not left yesterday.
My lord.
Then you should have been courteous to the court by giving a prior adjournment slip. You are in midway, you are not there, we are looking at the documents, we are asking questions. And in the meantime, you come and then say for an adjournment. No, we refuse it. You should have been more vigilant. You don't take the court for granted. You should have some respect for the court. And you know that we come here with some preparation. You could have asked us yesterday to buy a circulation, not to read the brief. You see, it's a case of Wakaf. It's there are questions of Mutawali. Then there is an appellate order by the Wakaf board. There is a original proceedings. We read all this and come and then you ask for an adjournment. No, we refuse it. You either assist us, you don't assist us. It's your choice. Is the name in the list of letter of absence?
No, my lord.
No. Then we refuse your prayer. How do you sustain this decision? How do Mr. How do you sustain this issue number 4? How do you sustain this issue number 4? Page 70, 75 onwards. How do you sustain that?
Page 70,
Page 75, issue number, the issue
Four.
number
issue number
4.
4.
How do you sustain it? This.
Yes, Lordship, that is based on evidence on record.
No,
Based
no.
on evidence on record.
Evidence will come, is the second part.
Yeah.
The first part is the primacy which should be given to the deed of Wakaf. Now, that does not say about literacy. You see, in a Mohammedan society, literacy is counted on the basis of the knowledge of knowledge of your text what is that, Quran. It's not dependent on the, what you call, other education. You may be a graduate or double graduate or an advocate,
No, he,
but the question is whether, you see, the Waqf board should have, has said, has held, number one, that as per the deed of Waqf, the respondent, sorry, the petitioner is, sorry, you are, of age.
Lordship, in Annex 4, para number 3, it is writ- also peruse an affidavit so and so that is submitted by so and so petitioner in regard to seniority. Now, herein, they have drawn a conclusion. Applicant Nurul Islam Chaudhary is the applicant, and Abdul Khalik Chaudhary are two contesting candidates for mutawalliship of the work. Both are literate persons, and both of them have equal ability to run the work estate. But Nurul Islam Chaudhary has the privilege of being the senior most by age over his opponent Abdul Khalik.
Yes,
It is the conclusion of the.
yes. What is wrong in this
So-
conclusion?
I am also qualified.
Question of, you see, when there is everything is equal, then age will come over.
Age
So in age, Nurul Islam
is senior to me.
is more aged than you.
Yeah.
Then how do you sustain this issue number 4?
Okay. The Planet Tribunal considered at page page 76.
76, I'm there.
Yeah. If
The petitioner is a double graduate.
OP
Nurul Islam is only holding a PU.
PU.
Correct. No, I personally know few Maulvis who are not even educated.
Senior.
They are hardly class 10,
Logic.
but they are the Maulvis in mosques. And they are revered.
I am admitting that he is senior to me. But regarding qualification,
No, but you
It
see,
has been clearly
qualification is only in the Waqf deed.
No.
There's 2 qualification prescribed.
Two.
Number 1, he should be pious.
logic,
Now to assess piousness,
Yeah.
There's no evidence at all.
logic.
In piousness, 2 or 3 virtues are there. Number 1, if you know the Quran, recite the Quran by heart, number 1. Number 2, for the purpose of piousness, you can also demonstrate by showing that, well, you are paying your zakat appropriately,
Okay.
and you do all the other, you read all the 5, you perform all the 5 namaz.
Logic.
So these things are not even assessed.
Logic.
Piousness,
In this case, one fact may be considered, that is, what are the written substance of the work deed?
of the Waqf deed.
Work.
Yes.
That means, what are written there? It is specifically stated that the wakif.
If
he
at
would
any
be the
time,
first
if
mutawalli,
at any time two amongst the descendants are
Yeah.
equally efficient and pious,
pious. That is
one who
another-
is elder shall be appointed.
that
Now,
is
efficiency is not assessed. There is no scale of assessment of efficiency.
logic.
And number 2, piousness, neither the board nor the Waqf, neither the Waqf board nor the tribunal
Logic.
made any assessment of these 2 factors.
What is the intention? That is page 16 make vision. Page 16.
I'm there at page 16.
Yeah.
I'm reading that
During-
part.
During my life, that is the wakif himself has
Correct.
says, my life, time, the management and preservation of the work property shall be remain with me. He would be the mutawalli. Then thereafter, after the payment, thereafter, and after my death, my son Isad Hussain Chaudhary, he was Mutawalli, will remain as Mutawalli. In this way, amongst their son's son, and after them, amongst their son's son, who will be suitable, efficient, and pious. Suitable, efficient, and pious. According to the opinion of the pious Muslim community, shall act as Mutawalli and manage as per the rules laid down in the Waqfnama. If at any time two persons, that is important, amongst the descendants are seen to be equally efficient and pious, one who is elder shall be appointed as Mutawalli. If at any time none found suitable, efficient, and pious in my dynasty, or any Mutawalli act contrary to be the provision of the Waqfnama, then entire Muslim community or social hakim will appoint an efficient person as Mutawalli or remove the existing. Herein, everything was okay, but last Mutawalli was his descendant Jalaluddin Chaudhary, but he was removed.
I understand. You see, number one, if two brothers in the family quarrel, who shall I say is a pious?
That is to be decided by the pious Muslim community here in Hespa.
I understand. But you see, two people are quarreling for the post of Mutawalli. So number one, pious goes. Correct. Now, they could have been a joint Mutawalli. We don't know. I'm just saying it in a lighter way, not very serious about it. But the second is about the efficiency. Now you see, let us take another bad example. I am giving a horrible example, but you see, there is one person who is uneducated, but every night he moves around his land with a lathi in the hand and is very efficient not to allow any thief to come in. Correct. I'm just giving a horrible example. Now, in this case, what is the parameter by which either the board or this tribunal has decided these two factors of efficiency and piousness? It is not. So therefore, both of you fall back on the only one ground about the age.
Right. Besides that, I have two other law points.
Please.
Section 83, subsection 9.
83, yes, I have there.
83, subsection 9.
Yes.
No appeal shall lie against any decision or order, whether interim or otherwise, given or made by the tribunal. No appeal. Then, provided that a high court may, on its own motion or application of the board or any person aggrieved, call for and examine the records relating to any dispute, question, or other matter which has been determined by the tribunal for the purpose of satisfying itself as to the correctness, legality, or propriety of such determination, and may confirm, reviews, or modify such determination or pass such other orders as it may think. It clearly speaks of revision, filing revision. And to this section, we have also our own High Court decision, Lordship. Then, Lordship, may kindly see their prayer portion, para number 12 of their petition.
Where do you say it's revision? Where do you say it is revision?
Actually, from the language itself, it can be inferred that while call and examine the records of any dispute. Subsection 9, second paragraph.
Just a moment.
Correctness, legality,
Just a
and
moment.
propriety.
Just a moment. Yes, what you're reading?
Herein, the language speaks of High Court may call for and examine the records relating to any dispute, question, or other matter which has been determined by the tribunal for the purpose of satisfying itself as to the correctness, legality, or propriety of such determination, and may confirm, reviews, or modify such determination. That is the language. And Lordship may kindly see their petition, page 12, prayer portion. Prayer portion. Under the facts and circumstances, it is therefore prayed that your Lordship may be pleased to admit this petition called for the records, issue rule calling upon the respondent to show cause as to why a writ in the nature of certiorari, mandamus, or any other appropriate writ or direction shall not be issued, quashing and setting aside the order dated so and so passed by the work tribunal at Kasar in so case number, and pass other order or orders either directing continuation of the petitioner as Mutawalli of Ghulam Raza Chaudhary Waqf Estate in Hailakandi district as appointed by the board, or directing the respondent number 3 to arrange selection. They are speaking of final selection. It is their prayer. Selection of the efficient Mutawalli for the said work, taking the opinion of the pious persons of the district for smooth functioning. That is their prayer. And beside this, in the writ petition, they have not stated that they have no other efficacious alternative remedy.
Yes. Yes, what is the alternative remedy available?
Yes, that has not been averred in their petition.
No, the question of averment is not there. Mr. Ahmed. There's no provision for further appeal.
Yes,
So you'll have to tell us what is the alternative, if that is not written,
not really.
what is so wrong?
Yeah.
So that we dismiss the writ petition.
We have raised 2 preliminary objections in our
That you have taken the ground of this Asadur Rahman.
Asadur.
How does this decision help you? This Asadur Rahman, how does it help you? I will tell you why I don't find this applicable. You have a decision of this Asadur Rahman. You have a copy of that?
Yes.
Please, no, I'm not requiring it. Please read that. Second last paragraph of this judgment.
Lordship, yes, I have got it.
Please read the second last paragraph of that judgment.
Second last.
Yeah. You are the students assigned in this courtroom? You all are students assigned in the courtroom? You have been able to follow what is being deliberated in the court? Correct. If you are in courtroom, please understand the deliberation. Then only you will be able to catch what is going on in the courtroom. Correct. We are dealing with Waqf Act, an appointment of Mutawalli. So please try to follow what is being deliberated so that you can understand a bit of it. We don't expect you to understand everything of it, but please pay attention so that you can understand a bit of it. Correct. It's not everyday litigation when you hear this issues of Waqf Act and appointment of Mutawalli and in a Mohammedan will of Waqf. Yes, you have read the last paragraph.
Yes, Lord. Paragraph 10. As already noticed, it was the petitioner herein who filed WPC number so, which was dismissed by this court. However, no appeal was apparently preferred by him from that judgment and order. In my opinion, the findings against him therein have now attained finality. In that case, this court has already found that in pursuance of the resolution dated so and so, the Board of Work West Bengal, the name of the respondent number 1 was already recorded as joint mutually in place of her father, late Ronak Ali, and that an affidavit was also sworn by the petitioner himself that he has no objection. As regard the appointment, there is a consent.
No, that's okay. As these findings have not been challenged, the operator is adjudicator. That is the
Great.
finding number 1. Then please proceed.
Uh,
I'll tell you in short,
Yeah.
what is there is in the following part of this paragraph, it says that insofar as the finding of the tribunal is concerned, there is no jurisdictional error, and therefore 227 is not maintainable. Correct. Now, please see this. It was Dasji.
I may be given 1 week time to clear all these queries. And by the time, perhaps his senior will also be coming. It will be better.
No, we are not
Yeah.
adjourning it. We are not adjourning it. Okay. There's a flag, page 396. Page 396. That is superintending jurisdiction of this court. In the next page 397, you will find those over which we exercise our superintending jurisdiction.
Super.
On the
227.
next page. On the next page, 397.
No.
Correct. Now, the work of tribunal is not covered by the superintending jurisdiction.
No.
Correct. It's not there. It's not in the schedule. So if there is not in schedule, so Article 227 itself would not be maintainable before this court. Therefore, this judgment you are citing of the coordinate bench, 2010 5 GLT, that will not be what you call applicable on the facts of this case. So therefore, this is not 227, and therefore we are not required to examine whether there is a error of jurisdiction. That's number 1. You have this. I'll show you another thing. Yes. Now, this is in the High Court rules, this is the form of writ petition. Now, after the Guwahati High Court of so and so, read the next line. After High Court of so and so, what is the next line? It is
High Court of Personal Revisional Jurisdiction.
divisional jurisdiction. So contrary to whatever whatever you think, a writ petition is not extraordinary jurisdiction.
No.
It's a revisional jurisdiction. Therefore, essentially, when we exercise power of writ, we also exercise the power of revision. So therefore, for the purpose of the revision of the order, we derive power from the High Court rules itself. So you see, 227 may not be required because 226 itself is a revisional jurisdiction. But it's a matter of prudence why we entertain in certain cases under 227 is because of the fact that under the High Court rules, the prescription is of 227 is superintendent jurisdiction, which is prescribed under the schedule of that chapter. So once this is not there, you have to interfere with the order. We'll remand the matter back to the Waqf board, sorry, act. No, sorry, it will go to Waqf board for making a reassessment on the basis of efficiency and piousness. And then if these are equal, then age. We will be remanding the matter back to the board. Let's take down. Your name?
M.H. Soikamal.
Mr. M.H. Chaudhary,
M.H. Soikamal.
Saikia,
Saikia.
okay, learned counsel for the petitioner has prayed for an adjournment on the ground that the learned counsel holding the brief is out of station for medical treatment. Full stop. The prayer for adjournment is refused as the petitioner, as the learned counsel for the petitioner did not circulate the memo of adjournment in advance. Full stop. Next para. Heard Mr. A. Saad, learned counsel for the respondent. Next para. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has challenged the order dated 30/11/2016 passed by the Waqf Tribunal, Silchar, in
Miss case 01.
Miss MISC, Miss full stop, Waqf, bracket close, case number 1 of 2014. Full stop. By the said order, the decision of the CEO of the Waqf board, Silchar, dated 25/1/2013, was set aside and the respondent number 4 and the case was decided in favor of respondent number 4. There is this preliminary issue of 4/8/2015, order of 4/8/2015. Where is that? What has happened on 4/8/2015? 4/8/2015. You'll find this in page 75. Oh, no, not page 76. In page 76,
Yes.
in the second paragraph, last part, in view of the decision of Honorable Court in GLT 2010, page 422, the tribunal decided the preliminary issue on 4/8/2015. Against the said order, Nurul Islam did not prefer any appeal or revision in the higher court. So what is that? What is that order? It is 4/8. 4/8/2015. 4/8. That's it. Not an accident. No problem. Preliminary issue. That's correct. In brief, the case of the petitioner is that one, the predecessor in interest of the petitioner and respondent number 4, namely Gulam Raja Chaudhary, GULAM RAJA, next word, Chaudhary, CHOUDHURY, had registered a deed of Waqf dated 1928, which was registered on 2/10/1928, and thereby constituted a Waqf estate in respect of 39 Bigha -7 Kata KATA -9 Chatak CH8 in respect of land measuring, so and so, of village Rangaiti, RANGAUITY, part -Roman 2 and Roman 3 in the district of Hailakandi. Amongst others, it was provided in the said deed of Waqf that after his death, his son Irsad IR SAD Hussain Chaudhry will remain as Mutawali MUTAWALI. And in this way, his son's sons, SON apostrophe S, son's son, and thereafter their sons, apostrophe S, son's son, who will be suitable, efficient, and pious, according to the opinion of the pious Muslim community, shall act as Mutawali. Full stop. It was also provided that if at any time, persons amongst the defendants are seen to be equally efficient and pious, one who is elder shall be appointed as Mutawali. Full stop. The relevant clause 1 of the deed of Waqf, relevant for this determination is quoted below. Page 16, blue pencil. I'm putting a flag. Next para. By an order dated 24/1/2013, the respondent number 4 was provisionally appointed as Mutawali by the Chief Executive Officer and Assam Board of Waqfs, WAKFS. Thereafter, on the basis of applications submitted by the petitioner as well as the respondent number 4, the Chief Executive Officer, Assam Board of Waqfs, by an order dated 25/11/2013, appointed the petitioner as Mutawali of the Ghulam, Ghulam Raja Raja Chaudhry, CHOUDHURY, Waqf estate, being the senior most Aulad, AULAD, beneficiary as per the provision laid down in the Waqf-Nama number 3586 dated 2/10/1928 in place of respondent number 4, sorry, you say Abdul Khalik Chaudhary, ABDUL KHALIQUE, Khalik Chaudhary, within bracket, respondent number 4, comma, the provisional Mutawali. Full stop. Next para. The said order dated 25/11/2013 passed by the Chief Executive Officer, comma, Assam Board of Waqfs, was assailed by the respondent number 4 before the Waqf Tribunal, Silchar, under section 83 within bracket 1 and within bracket 2 of the Waqf Act, comma, 1995. Full stop. The petitioner herein contested the proceedings by filing his written statement full stop. Accordingly, on the basis of pleadings, comma, the following issues were framed. Page 62, 1 to 7, blue pencil. Next paragraph. The respondent number 4, comma, who was the petitioner before the Waqf Tribunal, had examined himself as PW1 and he had exhibited the following documents. Mr. Saad, what is this exhibit 2? It is not very clear. Page 64, I am at page 64. He is most educated one wide exhibit 2. Now, what is this document? Page 64. You say this, he has exhibited 14 documents. There are only 14 exhibits. That is also not very clear. How many exhibits are there? Please try to find out. The petitioner herein was the he was one of the respondents in the proceedings before the learned work of tribunal.
These are not
Had
mentioned.
examined himself as DW1. No. He had examined three documents marked as exhibit A, B, and C. In the above, right, 14 exhibits marked as exhibit 1 to 14. EXT, exhibit 1, TO2, exhibit EXT, 14. This Nurul Islam's exhibits are how many? Please try to find out that also. Next product. From next paragraph, from the impugned order passed by the work of tribunal, passed by the learned work of tribunal, it appears that the learned tribunal had taken up issue number 3 regarding misjoinder and non-joinder of parties. Mr. Saad, where is that issue number 4?
Yes. Number 4, page 75.
Page
75.
75. Huh.
Last paragraph.
This is one of the most clumsiest judgment I have found. You see, I'll tell you why I'm referring this to be a clumsy. Come to page 72. This is a judicial officer, we expect him to be better. You see, issue number, page 72, issue number 5.
Right.
In issue number 5, he writes the petitioner states that in view of decision on issue number 4. Issue number 4 is decided later on. Correct. You have pointed out that it is at page 75.
No,
So decision is at 75 and 72, he writes about the issue number 4, then
four is-
decision not even come.
Hmm.
And they had only decided issue number 3, 4, 5, 6, and 7. Next para. Next para. In respect of issue number 3, it was held that the case was not bad for non-joiner of omni-joiner of parties. So in respect of issue number 4, it was held that the respondent number 4, Abdul Khalik, is well educated and literate in comparison to the petitioner herein, namely Nurul Islam. And accordingly, it was held that the order of the Chief Executive Officer, Assam Board of Waqfs is not correct, legal and valid in terms of Waqf-Nama number 3536. Full stop. In respect of issue number 5, it was held that the respondent number 4 had not taken over charge of Mutawali. Stop. In respect of issue number 6, Yes, Mr. Syed, on issue number 6, what is the decision?
Yes, issue number 5 and 6 are decided together. Conclusion is that in view of decision of issue number 4,
That's okay. But issue number 6, what is the decision in issue number 6?
issue number
Page 72.
Hmm. Hmm. Yes, the petitioner further stated in his written argument. He has considered written argument for appointment and removal of Mutavalli under section 32(2)(g) of the Waqf Act will constitute an order made under this act. Then persons aggrieved by such order can file application under section 83 subsection 2 of the Waqf Act 1995 before the tribunal. The tribunal will decide such dispute as per decision of Honorable High Court as published in GLT 20105, page 425.
There is no decision.
Yeah, decision
In
full
page
citation
76,
is not given.
in page 76, right, you should decide it in favor of the petitioner.
Full citation is not given.
In relation to issue number 6, although there is a discussion, but the finding cannot be easily deciphered. DCIPHERD, deciphered. First of, however, in the later part of the order, it has been reflected that in view of decision on issue number 4, in favor of respondent number 4, comma, issue number 5 and 6 is also decided in favor of the respondent number 4 herein. Full stop. In respect of issue number 7, come on. The decision of the Waqf Tribunal is not very clear. First of, however, in the later part of the judgment, it has been mentioned that the issue number 7 is also decided in favor of the respondent number 4. First of, accordingly, the decision of the Chief Executive Officer, comma, Assam Board of Waqf was set aside. Full stop. Next paragraph. It may be mentioned that although by the impugn order dated 30/11/2016, the decision of the Assam Board of Waqf dated 25/11/2013 was set aside. But there is no positive direction to appoint the respondent number 4 as the Mutawalli of the Ghulam Raja
So
Chaudhary Waqf Estate. Mrs. Had, am I right?
right.
There's
Ghulam
no,
Raza Chaudhary.
there's no direction. Stop. Next para the So the respondent number 4 has contested this writ petition by filing a affidavit in opposition, justifying the appointment of the respondent number 4 as the mutawali of the said work of estate on the ground that the petitioner is the respondent number 4 is a double graduate with a degree of BA LLB.
Yeah, and then
BA LLB, and is an advocate by profession, and therefore it is claimed that he is more better educated than the petitioner herein. Full stop. Next para. The respondent number 4 has filed an additional affidavit on 3/9/2018 to project that during the pendency of the writ petition, the petitioner has illegally sold a part of the work of property to one HRM Memorial Trust, Hailakandi, and that the respondent number 4 has filed an objection before the Deputy Commissioner, Hailakandi, on 17/1/2018, for which an inquiry stated to have been initiated. Next para. It may be mentioned that the learned counsel for respondent number 4 has made his submissions in support of the candidature of the respondent number 4 on the ground that he is more educated, and therefore the respondent number 4 is more qualified in education, and that being an advocate, there cannot be any doubt that he is not efficient, and that he has all other qualifications to act as a mutawali, on the ground that the members of the Muslim community had nominated the name of respondent number 4 to be the mutawali of the said work of estate. Next paragraph. From clause number 1 of the work of deed, which is the work of deed dated What is the number of the deed? Look up. What is the deed number, Mr. Sahad? Wakaf deed. Dated 12/8/1928, comma, registered on
Because there is no mention in
no, it's not there. What is the date of registration?
19 there
1910,
to 1928.
1928. Okay, 1910 to 1928. Comma, is extracted herein above, herein before. Comma, the settler has provided that in the event at any time two persons amongst his descendants are seen to be equally efficient and pious, comma, one who is elder shall be appointed as mutawali. Full stop. On a perusal of the materials on record, you'll find that neither the Board of Waqf Assam nor the Waqf Tribunal made any effort to find out as to who out of the petitioner and the respondent number 5, for number 4, are efficient and pious. According to the opinion of the pious Muslim community. Full stop. Hence, comma, the court is of the considered opinion that the Assam Board of Waqfs, WKFS Waqfs, as well as the Waqf Tribunal Silchar have both not considered the clause number 1 of the deed of Waqf full stop. In the first of at least from the contents of the order dated 25/11/2013 passed by the Assam Board of Waqfs, comma, it is not evident as to whether any effort was undertaken to determine the efficiency and piousness of the petitioner and the respondent number 4. Moreover, comma, the learned Waqf Tribunal, Silchar, had also not determined as to who amongst the petitioner and the respondent of who was more efficient and more and pious. And what was the opinion of the pious Muslim community before taking a decision in the matter? Full stop. Next. Insofar as the impugned judgment, impugned order dated 13/30/11/2016, passed by the Learned Worker Board, Silchar is concerned. We have already indicated here and before that the finding by the State Learned Tribunal on issue number 5 and 6. 5, 6, and 7 is not very clear. And only from the last part of the order, it can be seen that the issue numbers 5, 6, and 7 were decided in favor of the respondent number 4 EIN. So therefore, not therefore, moreover, even though the appeal of the respondent number 4 was allowed, there's no positive direction to appoint the respondent number 4 as the Mutawali of the Ghulam Raja Chaudhry Waqf estate. Full stop. Therefore, we do not find therefore the court is next part. Therefore, the court is inclined to hold that the impugned order dated when 30/11/2016 passed by the Learned Waqf Tribunal, Kachar, Silchar, in Miss within bracket Waqf bracket close case number 1 of 2014 is liable to be interfered with. Next paragraph. It may be mentioned that the Learned Counsel for the petitioner had placed reliance on the case of Asadur, ASADUR Rahman, ROHMAN versus Lutfa, LUTFA Islamic, within bracket 2010 within bracket 5 bracket close GLT 422 and it was submitted that this court by placing reliance on the decision of the Supreme Court of India in the case of Surya Devi, Surya Devi, RAI versus Ramchandar, RANCHANDER, RAI, and others. Had held that as there was no jurisdictional error in the order, the revision under Article 227 of the Constitution of India was not maintainable. Full stop. Next para. In the said regard, the court is of the constituted opinion that under the Guwahati High Court Superintendents of Tribunals Rules, 1992, the Waqf Tribunal are not under the superintending jurisdiction of this court. Stop. Under such circumstances, there would be no bar to assail the non-appealable order of the Waqf Tribunal before this court. Full stop. Moreover, in the discussions above, this court has already held that in the order passed by the learned Waqf Tribunal, the finding on issues number 5, issue numbers 5, 6, and 7 is not very clear. And therefore, the said order otherwise warrants interference of this court. Next para. Now, Mr. Saad, and you also. Oh. Yes, you also. Now tell us whether the matter is to be remanded back to the Waqf board or before the tribunal. Which will be better?
Tribunal will be better.
Tribunal will be better.
Because they are coming
Accordingly.
against their decision.
Okay. Next, accordingly, by setting aside the said order dated 30/11/2016, passed by the learned Waqf Tribunal Kachhar, Silchar, in Miss within bracket Waqf bracket case number 1 of 2014. The matter is remanded back for a fresh decision by the said learned tribunal. Stop. In view of the contents of clause 1 of the registered deed of Waqf dated 1910-2000, 1928, where the manner of appointment of Mutawalli in case of two descendants. If two descendants are found equally efficient and pious, comma, the court hopes that the learned Waqf tribunal council shall take note of the same and decide the matter on the basis of the prescription provided in the deed of Waqf. Full stop. Next, as the impugned judgment has been set aside, comma, it is provided that the matter would be taken up afresh from the stage of framing of issues. Next paragraph. In view of the discussions above, comma, this repetition stands allowed to the extent as indicated above. So the parties are left to bear their own cost. Sure. Now, what about the preservation of the property of the Waqf estate? Additional affidavit was filed. What to do about that?
Actually, they are claiming that they are managing their property. But there is
No,
no
I don't
such-
know. You see, we won't say anything.
Mm.
We have read, I have asked you to read issue number 4, 5,
Oh.
7.
There is
There is
no-
no clarity. Who is actually managing the property? We don't know.
No.
Decision not very clear.
not clear. From judgment itself is also.
So according to that order, you were appointed as Mutawalli.
Not. And board has also not filed any affidavit regarding status of that property. Board has also not filed any affidavit regarding preservation or any status.
No, we don't know. That's why we are asking you what to do. It was your affidavit, so we are asking you what to do about that. I said, just say, before this last part, that insofar as the additional affidavit is, affidavit filed by the respondent who is concerned,
Board may be asked,
comma,
what is the
The-
present
the-
status regarding?
the respondent who may be well advised as to the future course of action, he may so intend to take for preservation of the property. That's all. Let's stop. Okay. I'll take a break and come back. Next paragraph. The last paragraph. As both as the petitioner and the respondents are both represented, comma, they would appear before the Waqf tribunal, comma, Kachar, comma, Silchar, on 5/8/2024, and by producing a certified copy of this order, comma, seek further instructions from the said learned tribunal.
Item 9 for hearing.
Before my senior starts, I'm extremely sorry. As per the last order, I was supposed to file an affidavit. I have received the parawise comment has been received long back. It was entrusted to a different advocate, but there are some annexures and I paid just 7 days time to file the affidavit. It's my mistake. I had missed as per the last order dated 18/6.
What is your instruction? What is about the only issue is about the
stepping,
pay.
the
the
pay,
stepping up.
whether the stepping up, the letter dated, the impugned letters talks about that the corporate communication has not been received. To that effect, the Paraverse comment I had produced, they have mentioned around 7 annexures, but the annexures are not with the Paraverse comment. So this is my fault. I should have pursued it. The 7 days time, Lordship, just 7 days time. Next week, it may be listed and it may be decided.
Because the reason, Mr. Das, is that in 2017, when this writ petition was filed,
Yes.
he was 62. Now we are 7 years more. So he's about nearly 70.
Lordship, that is true, and it was dismissed for default in between also.
No, it's okay.
So there was, I had received it in 2022 only. This is absolutely my fault. I'm taking the onus on me. Just 7 days time, just onus is on me. I should have done the thing. I have not done it.
All right. But it's.
The 7 days time and no further exit.
His scale of pay was upgraded. Now
It was downgraded.
it was downgraded, but they have not acted upon it.
It's okay. You've seen that, that's why.
Simple on that point.
Mr. A. Das Gupta, Learned Senior Counsel. Assisted by Mr. J.U. Ahmed, Counsel for the petitioner is present. Mr. R.J. Das, Learned Counsel for the respondent numbers 2, 3, 4, and 5. Has paid for the time of 7 days to file affidavit in opposition with matter. First of all, where is allowed that the affidavit in opposition be filed by 24/7/2024, list on 29/7/2024.
Deeply up. Deeply up.
But take the number of Mr. Ahmed and then serve it to him.
Item 10,
May please, your Lordship. Lordship, before the petitioner starts, Lordship, just one point, Lordship. In fact, Lordship, here, Lordship, the petitioner, he was transferred to Lordship Kohima, Lordship. He have challenged his transfer order. Lordship, subsequently, Lordship, the petitioner did not join in the post of posting, and he tendered his Lordship resignation. That resignation order was inter alia challenged in writ petition number 6575, and Lordship has already dismissed the Lordship writ petition upholding the resignation order. In that view of the matter,
Where is that order?
Lordship, this is the order.
I want to also make submission on this regard.
Lordship.
Sir, Supreme Court has registered my grievance that they had taken the order fraudulently, and 5 complaint is already in the process. Supreme Court has.
Just a moment.
Lordship order, Lordship.
They are entering after filing the affidavit in reply. The respondent counsel, petitioner counsel enter in the criminal conspiracy for fraudulently taking the judgment and order in the 3 writ petition, not 1, 3 writ petition.
Lordship will file the
3 writ petition in 3158/2015 8653 20186575/208. And also CBC also registered the case that public servant engaged counsel had entered into a criminal conspiracy. CBC also filed. Okay.
Lordship will file that operative portion at page, Your Honor, paragraph 20, that is at page 13.
paragraph 23 and most important portion is a paragraph 29. That is a page on a 20.
They fabricated, all the fabricated, they have made submission on the fabricated false evidence. Concealing this document enclosed in the writ petition 8653.
Just a moment. Where is the order of the Supreme Court? You said
I am giving sir that. No, they have registered the complaint. They must come back. I am getting on there, sir. Five is still sir, pending. 391, 391, 394.
page.
Okay, sir. 391, 391. Yes, sir, after 3879, annexure 32. Annexure 32 say,
No, give me the page number, not the annexure number.
sir, 387. Sir, this is there. This, yes. 387. Three nine zero.
387.
Yes, sir. 387.
What is this?
The Supreme Court has registered that and it is shown and the complaint is under process. Therefore, five grievances are they are registered. CBC also registered a complaint, sir. Vigilant case. The public servant engaged counsel have entered in the criminal conspiracy.
The 387 does not mean anything to us. You show us your complaint. Where is your complaint?
Complaint has under that, sir. The complaint is under that. 388.
388.
Yes, sir. This is a complaint is shown under process.
Some is a document written to the Chief Justice of this court.
Yes, sir.
Then
So,
where is the,
one copy I forward to sir, Supreme Court. But this is a procedure, sir. The Supreme Court again forward here, sir, because the case is here. The five, sir, complaint has, sir, is still pending.
you see, for all purposes, your present writ petition is infructuous. You have challenged the transfer order.
Yeah.
And the transfer, what you call, in the meanwhile, you have resigned.
But but that they have given the, sir, they have taken fraudulently that judgment.
No, that is okay, but when you have this order set aside, you renew your challenge to the transfer for the present.
Because of they forced my ears.
Lordship,
Consular,
Can we-
they forced
can
my
we-
consular. I am saying, sir, that
Mr.
my
Singh, can we
petitioner-
pass any order in your transfer petition when you are not in service?
pardon, sir? No, no, the court had stayed the transfer this order. No,
After you have resigned, what
Yes.
is the transfer order to do?
no, sir, the court has stayed that resignation that letter.
Where is that order?
So it is there, sir. It is also there in the petition 183. Read petition 183. 184, sir. Read petition 184. Read petition 184 is there.
Anything more you have to say?
This is, sir, I have to say a lot of things, sir.
No, lot of things is that, you see, please don't compel us to make unnecessary comments. You are a
Sir,
petitioner in person.
by sir showing the document in,
Mr. Singh,
yes, sir.
you
By
are-
showing
you
the
are-
document.
You are
sir,
showing me page 184.
Yes, sir.
Does it exist today?
No, sir, but they had taken the decision on this, they fraudulently. And that sir, criminal conspiracy has after the affidavit in reply filed in this.
No, no.
8653.
We are dismissing your reputation as infructuous. Once you are no longer in service, we can't
Sir,
entertain
I'm
this.
not, yes, sir, because already Supreme Court has registered, I filed affidavit in Supreme Court that this is the, they have taken the decision for the
You do whatever you want, but
Yes, sir.
the present reputation is
And-
infructuous.
High Court advocate involved in that. I have no, sir, no other alternative.
Please don't make insinuations on persons in absentia.
No, sir, I have not, I have forwarded the copy also.
Please don't make
No, the CBC
insinuations,
also registered the,
don't make insinuations against persons who are not present. This is something I will not take it in a good taste.
yeah, I have to file another writ petition that's they are taken for judgment fraudulently. There is a- there is another-
You do whatever you want.
Yes, because sir,
Please don't
lot
threaten.
of sir,
You see, Mr.
Mr.
Singh,
We have
Mr.
threatened,
Singh, please don't threaten the court of filing another writ petition.
sir, I am not threatening
It
the
is-
court, sir.
It is,
I am threatening the person who, I, sir,
we are, in this court, we have thousands of cases, so you all be plus one.
sir, sorry, sir, I am not threatening the court, sir.
No.
No, sir,
You,
I am not.
whatever, you see, I have taken an oath, till date I am in service, I will take up the matters. So therefore, if there is one writ petition also in the court pending, I'll take it up. If there are 10 lakh cases also pending in this court, we will take it up. Correct?
Yes.
So therefore, don't tell us that I'll file another writ petition. You may do so, nobody is stopping you.
Yes.
We are not, we are not putting any gag orders on you not to file a writ petition. Please do if it pleases
I
you.
say in this petition, they also
Please,
fabricated.
I am asking you only one question.
Yes.
Is the issue raised in your writ petition live?
So I think it is live because they had,
Why? How it is live?
because they had taken judgment fraudulently and the fraudulent judgment taken is a non-existent in the eye of the law.
Appellate forum was there, your lordship.
Yeah,
Intra-court appeal forum was there, your lordship.
Ask
because
you, we'll respond when you ask you.
frontally taken judgment is no judgment in the eye of law.
Heard Mr. Binay Kumar Singh, the petitioner in person. Okay. Also heard Mr. I forgot your name.
Lordship G Das on behalf of respondent number 12 and 13.
No, then you are from Mr. Das
Lordship, for the net fee authorities, your lordship.
for the net fee.
Yes, lord.
Your respondent numbers
Lordship 6, 7, 8, 9, 10, 11.
7,
7 to 11, your lordship.
7 to 11.
Yes, lord.
Mr. DJ Das. As well as Mr. U
G Das.
and Mr. G Das, Learned Counsel for respondent number
12 and 13, Lordship.
12 and 13. There's any Mr. CKS Barwa, you can appear as CGC as well as first name is Mr. CKS Barwa, then as CGC appearing for respondent number 1,
1, 2,
2, 3, 4, 5, 6,
yes, 6. It was registered company. What's up? 6.
7, 6.
Registered corporate accounts.
Next para.
Yes. No, no,
The case of the petitioner in person is that while he was serving as Deputy General Manager in NEDFI, NEDF small I. You write the full name, the Northeastern Development Finance Corporation Limited, within bracket NEDFI for short. Full stop. At that time, by an order dated 1/8/2018, the petitioner was transferred from Guwahati office of NEDFI to Kohima office of NEDFI. Full stop. The said transfer order dated 1/8/2018 Mr. Singh, this order of transfer is 1/8/2018.
Sir, 182, after that I filed a writ petition, 182. Then the
Where is that?
sir, it is there, sir. It is there in,
Is
it is there in page 78.
is under challenge in this writ petition,
Yes,
along with
yes, sir.
connected order dated
Yes, sir.
26/11/2018.
Page 75. Then, sir, Board of Directors
Be-
already
before that?
disposed my
3/10/2018, 26/11/2018, and before that,
757,
2012/2017.
75 it is.
Page number?
Page number, sir, page number 75. The board of directors are thoroughly disposed this and retains a estimated opinion against mine.
Next para. It may be mentioned that initially by an order number 21 dated 2017, the petitioner was transferred to the branch office at Kohima, branch office of Netfi at Kohima, Nagaland. The said order was assailed by the petitioner by filing WPC 182 of 2018. And this court had disposed of the writ petition with liberty to the petitioner to submit a representation within 3 days. And it was provided that until the representation is decided by the board of directors, within bracket, without participation by Mr. B. Paul Paul Mukti, Muktieh, the then chairman and managing director, bracket closed, coercive steps should not be taken. And that the impugn order dated 2017 will abide by the final decision of the board of directors of Netfi. Where is the decision of Netfi?
The decision in Netfi is a answer. And in order, sir, in order given in one.
Where is that?
The decision page 97 to 99.
97
to 99. Sir, I want to bring the one more factors. In order given in order given in sir
17/1/2018.
6575, the court has made observation. The procedure of that board meeting, in which my representation has disposed of. Court has made observation. Court has made observation that the respondent Netfi Corporation on their own come to conclusion that the action initiated by the petition against the management are due to frustration as reflected in the meeting of the board of directors of the corporation dated 26/2018. Court has made observations. So these are minutes is ex facie fraudulently detailed. Ex facie. A court has made also observation.
in the board of directors of Netfee by minutes of proceedings held on 22/6/2018. Held that the transfer of the petitioner in person was proper and in order. Full stop. Next plan. What is the date of your disputed resignation?
10/8/2018.
3/8/2018.
Yes, sir.
Next.
Because the court has, sir, board had written fraudulently disposal my complaint, written a statement opinion against me. That I made a fraud for covering of the fraud committed by board of directors. That illegal appointment of CMD, fraudulently sanctioning and disbursement of the loan, fraudulently taking the subsidy under the North Eastern Public Investment Policy. The board of director making, committing fraud. For covering of that fraud, they have written estimating opinion against me.
Okay. It
They are not one single fraud, 4 or 5 fraud they have committed.
there is a sequence of events which is not referred to. It would suffice to mention that during the pendency of this writ petition, the petitioner, where is the resignation? Where is the disputed resignation? Which document will I find it? Yes. Where is the-
Sir, that writ petition I have,
To take the second file, you're looking at the allowed.
sir, writ petition is, I have filed, sir,
I'm sorry, your lordship, but
one, sir, that is 100, sir, page 100. And I forward a copy to Sir Chief Justice also, because earlier I have made a complaint, sir. And also CBC, the CBC also registered the case on this, the way of.
Okay.
Page 100.
In the meanwhile, the petitioner by a letter
it's a winning. Yes, when I feel it Congress. Yes, 100.
My resignation letter is
Disputed was a letter from cases.
100 page and 104. I forwarded a copy to Sir Chief Justice also. Chief Justice,
15
the CBC,
2018.
because I make a written complaint to Chief Justice.
Resigned from the net fees. Full stop. So initially this code by an order dated 28/9/2018 passed in WPC 6575 of 2018. I had suspended the order dated 10/8/2016. Oh, something is wrong. It should be 2018. 2018. Passed by the net fee, releasing him from, releasing the petitioner in person from service. However, by a judgment and order dated 26/7/2021, passed by this court in WPC 6575 of 2018. The writ petition of the petitioner was dismissed. Full stop. The effect of the said order is that the release of the petitioner in person on tendering of resignation has attained finality. Next para. In view of the said judgment and order dated 26/7/2021, passed by this court in WPC 6575 of 2018, the court is of the considered opinion that the prayer for quashing of the transfer order dated 2012/2017 from 1/8/2018, 3/10/2018 and 26/11/2018 have become infructuous.
I want to bring one more sir. Right? Please see the page number 344. That's myself. I have given that, sir. Given, sir. 344.
Yes.
Before judgment is taken, I made a complaint on 9/6/2022 to Supreme Court. Supreme Court filed a grievance. In that grievance, I raised the issue that my petitioner counselor has enter into criminal conspiracy before the judgment.
I don't know. The person against whom you are making insinuations is not there. We're not hearing that. Next one. Although the petitioning person has tried to raise issues about his grievance, but those are besides the issue involved in the present date petition. Full stop. In the present date petition, the petitioner has sought for relief against his transfer from Guwahati to Kohima. Full stop. With the acceptance of his resignation, which has attained finality by the hearing before referred judgment dated 26/7/2021, passed in WPC 6575 of 2018, the challenge made in the present date petition against the order of transfer is not sustainable. Accordingly, on the ground that this, with the acceptance of the resignation of the petitioner, the present date petition has become infructuous, this petition stands closed.
Lordship, if I make prayer, Lordship, my DJ Das 4K inch of the Lordship, my senior names may be reflected. I'm appearing 4K inch of the senior Lordship.
No, don't make us say that. There are reasons.
Understand.
Because he's making grievances against.
I could follow, Lordship. I could follow.
So therefore.
Then I also
When I got-
that he also filed for only on IA 67. After that, affidavit reply filed, sir.
You do whatever you want.
Yes, sir. Because in affidavit reply, I said that the
No, please.
counter affidavit is
Whatever
for
you
the-
think.
after
Whatever,
that, sir, they,
Mr. Singh, whatever you think fit, please
Yeah.
do it.
it is not that I'm not complaining against him.
No, it's okay. You do whatever you want. You got nothing to say.
He also involved in the, sir, fraud.
Please don't make insinuations when
Sir.
you have not made any allegations.
Sir, I'm
It is-
given the written, sir, right?
in
That
this-
why, sir, the Supreme Court has registered. I've given the written, sir.
Please don't take things for granted. This is perhaps for the fifth time I am telling
Yes,
you.
sir,
In this writ petition, Mr. DJ Das is not a party.
He is also parties are in IA, and he appeared for.
Lordship, I filed
Please,
this. I was just filing
He
the
appears,
if you don't know the court proceedings, please don't persist.
sir, he appeared in
You will
the,
be at the receiving end.
sir, he appeared in the writ petition 6575. He appears.
You want an adverse order, you are inviting an adverse order,
No,
you
sir,
want
sir.
that?
So, no. Sir. So why should I invite the, because already I am
Then please-
quite victimized
Then
by
please
the.
accept what the court is telling you.
Yes, sir.
Don't make insinuations against persons when you have not arrayed them as respondents. We have time and again telling you they are not before this court. He is assisting the court as an officer of the court. Please don't make insinuations when in the writ petition you have not made allegations against them.
Sir, also, got to also, sir, maybe, sir.
You do whatever you want.
Bring the truth, sir. Bring the.
Please don't make insinuations when you don't give them an opportunity of defending themselves. If you do so, you are inviting adverse orders from the court. And if you want to test that, please, you are free to repeat it again, and then you will find that
Yes, sir.
how I take this test. This we are returning. The documents, please.
Because Supreme Court is saying that you please file with affidavit. Well, they are disposing that you're not signing.
I am not the appellate authority over Supreme Court of India.
Okay, sir.
Correct. What happens if the Supreme Court's action is not being followed? I am not the executing authority.
Okay, sir.
Correct.
They are saying that you are not digitally signed the.
Wait,
Complete-
you'll not learn unless I pass an adverse order.
Okay. No, sir.
At the After the closure of the matter, the petitioner in person has submitted that he has named two learned counsel, one senior advocate as well as the counsel for the respondent numbers. You have all? Respondent numbers
For 7 to 11, your lordship.
7 to 11. And it is submitted that they are party to a fraud committed on him, which has
Committed on
resulted,
sir.
which has resulted in passing of adverse orders in 5 writ petitions filed by him.
No, sir. 3 writ petition.
3 writ petitions filed by him.
Filed by against not all 3 writ petitions filed by me. So I have filed 182, 3 writ petitions. 182, 182,
182.
182 oblique
Just a moment. 182 of
2018.
2018.
2018. Second,
Then 6575.
of 2018.
Yeah.
Then
Then 8653.
The instant one.
of
18. Then IA 67.
IA 67.
2020. And then another writ petition they have probably taken judgment in 3158 oblique 2015. Another writ petition.
This is filed by whom?
Manoj Kumar Das. And Manoj Kumar Das. And all are taken in your court, sir.
So it is submitted that in 3 writ petitions, being WPC 182 of 2018, 6575 of 2018, and the present writ petition being WPC 865 of 2018.
653.
Stop. It is also submitted that in a writ petition filed by one Manoj Kumar Das, being WPC 3158 of 2015, orders adverse to the interest of the petitioners was passed, and which was obtained fraudulently by this bench. So stop. It is submitted that all the fraudulent orders was passed by this court and this specific bench. Full stop. This court had warned the petitioner on 5 occasions not to make insinuations against the learned counsel of the court, without arraying them as parties and giving them an opportunity to defend themselves. Full stop. Despite such pre-warnings on 5 occasions, even after close of this proceedings after the dictation of this judgment, the petitioner in person persisted with his allegations against his erstwhile employer, i.e. Netvi, its officers, as well as against Mr. K. N. Chaudhary, learned senior counsel, who appeared assisted by Mr. D.J. Das, learned counsel for the Netvi, in the proceedings of those writ petitions. Full stop. Moreover, from the nature of allegations made by the petitioner in person, an adverse inference can be drawn to the effect that all the writ petitions were decided by this particular bench. Full stop. Therefore, on account of insinuations made against the learned counsel, senior counsel, as well as the counsel, the Netvi in this, as well as on making insinuations against this particular bench, the court is inclined to hear the petitioner in person on those allegations, for which the court takes a recess at 1:15 a.m. and would resume at 2 p.m. to give an opportunity to the petitioner in person to respond to the above. Full stop. Court takes a short break and will resume at 2 p.m. Be there at 2 p.m. and tell us.
I have to start from the filing of 182. Sir, I have given the certified copy of my petition 182 in this letter. It is in page number 184 to 260.
Yes.
So, sir, I filed through Ansuman Sharma, Advocate Ansuman Sharma. First page.
Yes.
Then page number 13. I enclose, that is page number 13 of this writ petitions. I enclose a copy of my letter addressed to Honorable Chief Justice Guwahati High Court, dated 6/12/2017. Page in this 113. That writ petition is 13. In this
113.
113.
Yes.
So, sir, I have written this letter along with 25 annexure. Annexure is given. Annexure is given 137. List of annexure is given, which is attached with the Chief Justice 137 or 1.
Anything you are saying is in the writ petition. Where is the paragraph in the pleadings?
Pardon, sir?
In the writ petition.
Yeah.
8653.
Yeah.
Where is the statement in this writ petition?
Yeah, this is sir. Yeah, this is writ petition is here, sir.
The submissions you are making
Yes, sir.
is
Submission we made, that's
is stated where? Which paragraph you have stated that?
22.
Yes. Yes.
Then, sir, I have enclosed 25 annexure with this my complaint.
No. We started this, you see, after the dictation was over, we started this again.
Yeah.
On the basis of all your insinuations against the senior counsel in this.
Yes, sir. But on this
As well
day,
as well as against Mr. DJ Das.
yeah. Not my also my Ansuman Das, Ansuman Sharma.
Okay. Now, where is the allegations against them?
Because that's conspiracy after that's affidavit reply file. The conspiracy has entered by the Ansuman Sharma, K. Chaudhary after the affidavit in reply filed in 8653 on 3/1/2019.
Okay, you have filed any additional affidavit or any affidavit in reply in the matter?
No, sir.
Where-
Because
where
my
you have made insinuations.
because
against the-
my second advocate, I hired second advocate, Mr. Surjit Datta. He also started conspiracy with us. I hired second advocate, Mr. Surjit Datta. So how many advocate I can have, sir?
There is not the question of the court. The court question is that you are making insinuations against the senior counsel.
Yeah.
And Mr. DJ Das.
So
Now, where is the pleadings to that effect?
So this
there.
they know all this document. So they are part of the
No, no, what is there? I'm not, this is not my question. The
Yes.
question of the court is, where is the statement against the senior counsel and the counsel? for
Because
the-
I have no opportunity, because my advocate I forced by petitioner and
this-
responded
So in this petition, there is no statement against the counsel, correct?
in this petition, because the conspiracy is
Yes, sir.
entered after the affidavit in reply file.
That's correct. After the recess, the court has taken up the matter again to stop. On a query of the court as to in which paragraph of the writ petition or reply affidavit, if any, any allegation of fraud committed by his earlier set of counsel is narrated. To stop. In this regard, the petitioner in person has submitted that the fraud came to light later on, and therefore there is no statement on record in the proceedings of this writ petition. To stop. Next paragraph. The court is of the considered opinion that it is elementary in a in a adversarial litigation that a person against whom any adverse insinuations are made must be arrayed as a party, and the allegations of fraud is required to be heard in their presence. Full stop. Merely because of the fact that the that a counsel is present in court and holding a brief for the adversarial party would not give a license to the petitioning person to allege that the counsel for the respondents is a party to a fraud committed upon him. Full stop. Insofar as the insinuation against the court is concerned, wherein the petitioner in person has alleged that the respondents have been able to, inverted commas, obtain, inverted comma closed, orders from this particular bench, comma. The court takes an exception to such insinuations against the court, which affects the administration of justice. Stop. Therefore, it would be appropriate to issue a direction upon the to request the registry to examine the matter and to take a call as to whether proceedings can be initiated against the petitioner in person for making comments on this court. To project as if the court is a party to the fraudulent orders, inverted commas, obtained from this bench. Next slide. The issue involved in this writ petition was that after having resigned from service, which attained finality with the decision of this court, dated 26/7/2021, passed in WBC 6575 of 2018, whether the order of transfer of the petitioner was a live issue. Full stop. In this regard, the court is of the considered opinion that once the petitioner's resignation,
If it will reply, sir,
you are only increasing the cost. You're only increasing the cost which we are going to impose on you.
Sir, sir, please, 1 minute. In affidavit of reply file, I stated that they had fraudulently filed the affidavit, counter affidavit. In affidavit of reply, sir, para 7, para 7, para 6, para 7. Para 6, para 7, all para. पूरा para 6 से para 11.
Considering that after the resignation of the petitioner was accepted, which has attained finality in the judgment rendered in WPC 6575/2018, the challenge to the transfer has become infructuous. The issue cannot be a live issue when the petitioner is no longer in service. Therefore, for precipitating the argument after the dictation, after the judgment, after the petition was ordered to be closed as infructuous, the court is inclined to impose a cost of rupees 50,000 on the petitioner in person to be paid to the registry of this court within a period of 1 month. Failing which the amount shall be recovered in accordance with law. Next paragraph. The future cases filed by the petitioner in person, the registry is requested not to place any further petitions or any other proceedings filed by the petitioner in person before this bench in view of the allegations made by the petitioner in person against this bench. Deposit 50,000, you have to register this for within a month. Just one line, and despite fair warning to the petitioner in person not to precipitate the matter after the closure of the writ petition. I think last time, this was your cost. Your matters will not be listed before this bench. If any matter comes in inadvertently, please tell us not to take up the matter. You also please remind. Will not. The cost shall be made over to the Guwahati High Court Legal Services. The Legal Aid Committee. Yes.
Item 11 with 12.
May it please your lordships. 1992 item number 1. Hello, there are two matters, item number 11 and 12. Would your lordships kindly take up item number 12, my lord, same matter?
Mr. Sorry, yes, can we adjourn the matter for a day?
Yes, why not?
I understand. Yes, yes.
Okay. No problem.
There's something which happened.
I understand.
There's something which happened.
Absolutely no.
Maybe Mr. Mahanta will brief you.
No, it's all.
Not today. We'll take it up tomorrow, day after tomorrow.
No problem.
Day after tomorrow?
I'll let it be on next Tuesday.
Mr. Nayak?
Lordship.
You understand? Yes, sir. Also, it's a representative. Next thing. Okay, as agreed to by all sides. Let's the matter on. Next Tuesday is 23. 27, can it be 25th? You're not sure.
25th. Who does it? Let it be 23rd for the time being.
There's some difficulty. That means he'll be out of station.
No.
It's okay. Okay.
So we'll manage in case of any difficulty, we'll not.
Okay. Because he's having a.
No problem.
They have some difficulty.
Deeply.
Item 14.
This matter may be exempt for the day, the engagement of people is not physically well.
Also, it's a representative. Is under the understand of John. Therefore, if John is made on the there is allowed. This
Next month, my lord, any.
fifth August.
My lord, 6th, maybe is on 6th of August, my lord.
We are reserving few days for many matters and that's why we are avoiding hearing date.
On 7th.
7th, okay. 7, 8.
Hello.
Item 15.
Yes, Mr. Kumar.
My lord, in this case, my lord, my pay was, my lord, reduced, my lord, from 46,000, from 44,900 to, my lord, 46,200. The ground that, my lord, I complained, my lord, regarding food, my lord. As a result, the disciplinary proceeding was initiated. And, my lord, I was found guilty. Your lordship, turn to page 16, my lord. Page 16, my lord.
Just a moment. You see, they have not read fully, but we understand that you are on duty at a magazine,
My lord,
and as per the requirement, you have to have a mess food,
mess with my lord.
because the fact that the location is at a
Sensitive.
at a remote location,
My lord,
and therefore home food cannot be brought in.
my lord.
Correct.
Well, because of my lord stomach problem, my lord, I have lodged a complaint, my lord. That is at page, my lord, page, my lord, 16 at page, my lord, 23, and they have rejected my prayer, my lord. As a result, my lord, disciplinary procedure was initiated, and my salary was, my lord, reduced, my lord. This is the only ground, my lord. Complaining food, my lord, because of my stomach problem, I complain because of that, my lord. Such, my lord, harsh punishment cannot be, my lord,
No,
imposed.
just
my lord.
tell us. Because there is nothing, I did not find anywhere. Now you see, I have an upset stomach. Correct.
My lord.
Uh, you see, I have an upset stomach. Therefore, what I do is that when I come to office, I bring my own tiffin. During the lunchtime, I go inside and I have my own tiffin. Now the query is there any bar for a CISF constable to prepare his own food and
Yes,
then
yes,
bring it on
in-
duty?
In the magazine area, my lord. That's the problem.
No, you come from your home. Let us say your duty starts from 5 to 12, 8-hour duty.
My lord.
5 to 1, let us say your duty is 5 to 1. Now, is there any bar for you to have your food prepared before 5 o'clock and then bring it to your place of office or posting and have your food at 1 o'clock? Is there any bar that you can't bring in home cooked food? Because you see, I bring my home food. I start at 9:30 in the morning. So before 9:30, my food is ready. And I bring that food, and since I don't have anything else, I take that cold food.
My lord, actually, my contention is, my lord, very simple. My lord, can you see page 114, last page, my lord?
Page
Page
114.
para 10, my lord. Last page, my lord, 114, para 10. There's the final order, my lord.
Yes.
For 3 years, my lord. Reduction of pay one stage from in the time matrix for level 6 for a period of 3 years, my lord. So harsh, my lord. Only, my lord, I have complained, my lord.
No, because I find somewhere the stand is taken by the respondents that you did not only object, but you instigated. And therefore, it affects the discipline of the force. That is the allegation against you.
Otherwise, my lord, I have nothing to argue, my lord.
Huh?
Just I have nothing to argue, my lord, because food, my lord, I complained, and as a result, my lord,
But 3 years is, Mr. Das, 3 years is too harsh.
Lordship,
3 years is too harsh.
Lordship, that's a decision of the Lordship, my subject to correction, your Lordship. That's a decision. Lordship, nothing procedural labs has been conducted on the part of no procedural labs has been conducted.
So
in
still
being
3 years would have a very telling effect. These people retire at what age? CI, sir?
60.
60. So 3 year, what you call reduction of pay. He'll be too left behind for 3 years.
If it's 1 year, my lord, I'll, my lord, agree, my lord. If it's for 1 year, I'll agree, my lord. I'll not object, my lord.
In that case, Lordship, I will take certain instruction, your Lordship.
You take it better. 3 years appears to be
Lordship,
too harsh. What you call, you reduce him to pay matrix 6 for 3 years.
I'll have a word, Lordship, whereas it has come from Lordship, I will have a word with them, Lordship.
Please
Some
do
time,
it.
Lordship. will be given.
We'll take it up next week.
My lord, only, date may be fixed, my lord. Only on that ground, my lord, it will be hard. my
Okay.
lord. Otherwise-
Mr. Das, suggest a date.
Lordship, any date convenient, Lordship.
No, I'm here. Every date is convenient for me, whether I can take up your
Whichever
matter
date
is
is
different.
convenient for Lordship.
But every day it's convenient for us.
23rd July, my lord.
I don't know where he'll have to.
But Tuesday, Lordship, it is from Duliajan, Lordship, maybe on,
Okay, no, give a date of your
Lordship,
choice.
29th, your Lordship, if this is
29. Okay,
okay for senior council,
My lord.
okay.
29th.
Mr.
My lord,
Rahman,
I have no
Learned
objection, my lord.
Counsel
If
for
it is
the-
released for 1 year, my lord, I have no objection. I will, my lord, abide by that, any condition.
Excessive Rahman, Learned Counsel for the petitioner submits that the punishment of reduction of pay by one stage to pay matrix level 06 for a period of 3 years is too harsh. To stop. On the said submission made by the next para, on the said submission made by the counsel for the petitioner, comma, Mr. D.J. Das, learned CGC,
Lordship.
pays for some time to obtain instructions and to address the court on the quantum of punishment imposed.
Quantum of punishment.
List on 29/7/2024.
Item 16.
Lordship.
Because it's only for food. Yes.
They are disciplined.
FSC. No, that's okay. I'm not saying anything on that. But
I'm
for
taking
food,
instruction on
if he
this.
loses for 3 years, that's too much.
We'll have a word with them.
Please.
Much of that.
The matter, my lord, where you challenge the discharge of this petitioner from his service,
3 reading,
4 reading in.
4 reading.
4
huh?
reading entries.
4 reading.
uh, That he had earned the 4 reading entries in his service career is not disputed. He had 4 reading entries in his service, that is a matter of record. The only issue that perhaps Lordship would consider here is, would the fact that the petitioner had 4 reading entries be the only ground for discharging him from service? Or would something more be required of further delinquency or not meeting up to the mark of service would be required before he is discharged from service on the basis of 4 reading entries? This
I
issue
think that is already settled.
that is settled by this honorable court in a division bench matter, settled by this honorable
Supreme
Supreme
Court
Court
also.
in 2022 by in Amarendra Pandey case. And here, if Lordship has the order by which discharged, Lordship would have it at page 30.
Just a moment. Just a moment. Just a moment. These tablets even after taking home cooked meal.
What I've seen of the armed forces, the Central Armed Police Forces, they pick examples of persons and punish in a manner which would deter others from even thinking about going to that extent to maintain the discipline. So one person has to suffer so that a message goes to everyone in the land.
That's the basic principle of management.
Otherwise, my lord, in the CAP with the arms and ammunitions that they have or the training that they have, a little out of mind would lead to chaos inside the camp. That
You understand
aspect is
that
always there.
It's a preliminary what do you call Principle of management.
Even offences which perhaps would not have made much of a difference even inside the camp, if they find out something which could lead to
Unrest.
they
Yeah, we
immediately
understand
take
that. Yeah,
action.
we understand that.
In this matter, if Lordship has page 26 page 26 of the repetition. That will give the facts leading to this case. This person joined, sir.
Yesterday, in fact, having read this, I tried to have a cough syrup and my wife could not find a smell. That was the first reading.
They would have their reasons, we would have our replies.
I don't know. Having read this, I told my wife that I'll take an experiment. I'll drink 2 tablespoons of 2 teaspoonful of cough syrup. I took it, and after 5 minutes, that smell was not there.
But,
It was only an experiment. I don't say that I am a scientific officer. I've just taken a
now the cough syrups, they are kept devoid of alcohol in most cases. The other earlier standard of having some, what do we call it?
No, I don't know. It just, I take things in a
Suppressant.
lighter note.
What they call the suppressant in those days.
I take things in a lighter note.
Yes.
Oh, Mr. Upamanyu, I'm sorry. About my aunt, yes, she has developed a lung infection, but the doctor said that they will go ahead with the operation today. I'm not aware. I'll go in the evening. I'll go in the evening and I'll see my aunt.
Lordship, just now I had a talk with the principal, Lordship. He will give me the updated situation, Lordship, what happened. It seems
I'm
he is
taking his
very weak.
assistance. My aunt is in the hospital. He's being operated, so he's my man Friday today. It's okay. I've just spoken to them. They'll be operated today, but she has developed a lung infection in the hospital. We'll take a call and do it. Refer to her. Perhaps after the quotas, I'll visit her hospital.
Lung infections in the ICU are very common because they keep a
No, she's
person-
not in ICU.
Then it should not happen.
He's my aunt is
Otherwise,
about 85,
Right.
and she fell down and broke her hip.
Oh, keep that.
So being sedentary also it happens. You don't know. Lung infection can set in because the body is weak otherwise. But let us see. I've taken stock. I'm just telling you that.
Yes, yes,
that
you'll inform
maybe
me after
I'll
some
have to
time, Lordship, what happened.
Sometimes family members are more offended with us because we can't take care. We can't tell people. Ourselves can't be there. So at times people take offense of our situation.
more if one was more
But that's
connected.
why he's helped me out. Yes, thank you. Master. Yes,
Page 26 gives a history of the renegade
page
list.
number
26.
26.
Prior to that, my lord, page number 23, I had made a prayer for not discharging me on a notice being given to me.
Did you take up this matter earlier?
My lord,
Did you take up this matter earlier? No.
perhaps not, my lord. I do not remember arguing with my.
No, no, no.
Maybe one of
It's
my
not
previous
there. Not there.
representative.
Yes,
Page 26, my lord, you were enrolled as recruit GD on 25th of June 2025 in the Assam Rifles. Therefore, in your service of 16 years, 2 months and 6 days, you have incurred 4 raiding entries in your dossier. The details of the offences are as given below. Assam Rifles Act 2006, Section 35, intoxication. That was in the year, Lordship will note, it is in the year 2011. The next raiding entry came in the year 2015 for intoxication again. Then it came on 2017, absenting himself without leave. And in the year 2019, the last of the 4 raiding entries came for another incident of intoxication. The fact remains he did not appeal from these orders, he did not challenge these orders, and whatever, my lord, explanation he has tried to give as to why he was given the raiding entries, perhaps, my lord, would not be taken into consideration in this petition because he never put forward. Now, Lordship would have page 29. I'm sorry, my lord, page 27.
yes.
It is clear from the above that you, in spite of having advised many times to improve in your demonstrated professional conduct, did not show any change for better. You have thus become a repeated offender. Keeping this in view, it has become essential to initiate action against you in terms of Section 11(1) or 2 of the Assam Rifles Act 2006. You are hereby directed to show cause as to why action to discharge from service in terms of Section 11(1) or 2 of Assam Rifles Act should not be taken. You should submit a reply to the show cause. Now, this Lordship will note at page 26 is of the year 2021. The last of the raiding entries having come on 14th of November 2019.
Yes,
So therefore, my lord, 2 years had elapsed from the 4th raiding entry to the date of giving me a notice. And in between, my lord, it is not the case of the respondents that I had attempted or I had even been caught doing anything which was unworthy of the force. Nothing happened in these 2 years. Now, this letter was forwarded to me by page 29, 20th of September 2021. The commandant, he gives me this letter because it was through him. Now, Lordship would find at page 30 is the second show cause notice again. So from 2021, when I replied to this show cause notice and between 2022, on my reply, no action was taken by the department. They let me continue in service. And on 2022, without there being anything further in my career to show that I was repeating or even attempting to repeat any offense, in 2022, a fresh show cause notice comes to me. That Lordship will, I'm sorry, madam, that is the discharge letter. It comes.
No, but on earning on earning certain amount of red ink entries,
my lord,
you become entitled to what you call you make yourself liable for discharge.
Well, the liability for discharge, that is what the Supreme Court has held on 4 raiding entries, the liability to discharge would not be automatic. Otherwise, the 4th raiding entry would automatically lead to a discharge. I don't need a show cause notice. When I incur 4 raiding entries and the commandant thereafter finds that I am not correcting myself thereafter, then I don't need a disciplinary proceeding. The 4th raiding entry, along with whatever the commandant comes to a finding that this man is not correcting himself any further, the 4th has come, yet he is not correcting himself. He goes. That is what the Supreme Court has also said, saying that there may be 2 persons. Both may have earned raiding entries, one for an absence of 1 day while he was attending the mother in a hospital, and the other who incurred the 4th raiding entry because
But
he
in
was.
page 27, that is what is said, paragraph 2.
Madam.
That is what is being
So
said.
therefore, in paragraph 2, when he says that I am not correcting myself, something has to happen between the 4th raiding entry and the mention that you are not correcting yourself. If the 4th rating entry leads to a conclusion that I am not correcting myself, then the termination, the discharge will be automatic. It is only when after the 4th rating entry, a further conclusion is drawn. Then no, he's still not correcting himself. Then I don't need the 5th rating entry, or I don't need a disciplinary proceeding. Then it is in the hands of the commandant to say that this man is incorrigible. He doesn't listen.
And Lordship will see that after 2019 till 2021, no one forms that opinion. 2021, when I reply to it, 2022, the only factor given is you have earned four radiant rays at page 30. If one occasion of an intoxication on a particular day, on or off active duty is what I'm not arguing that. But one point of intoxication can earn me a radiant entry. But the gap between 2017 and 2022, where I did not make another mistake, would it still be enough for the commandant just to say that you are inconsistent? 3 years have passed in between. And it is not their case in the affidavit in opposition that there were minor or major delinquencies which were overlooked or which were kept on record. Nothing of the sort. And that is why this Honorable Court and the Honorable Supreme Court has held that a mere recording of 4 reading entries would not. There has to be something further to it. Because it is an option to be exercised. It is not a mandate. It is a discretion which has to be exercised. And a discretion has to be preceded by some conclusion, some finding, based on some materials.
Here, this is which act is being followed?
The Assam Rifles
Rifles
Act and Rules.
You have the collection of acts.
It is in the Assam Police Act. Some police law will happen.
I don't think we have that book.
Pink color book. Assam
I don't
Police.
think we have that. कहाँ से लेके था? That book is of whose book is that?
No, a hardbound book. Although it is the Assam Police Act and Rules, but Assam Rifle Act kon hona hai. Many of them think that anyone on that.
I think Mr. Vikram Chaudhary. Yeah, I went for another video series last night. Achha, just Assam Rifle Acts is to 2010.
The rules are 2010. The Act is 2006.
6. What is the section? 108.
They are referring to section 11, 1 and 2.
Sorry, which section?
Section 11, 1 and oblique 2 is what they say.
No, this raiding can all this, I think 102 or 108.
That is the record of instruction clause 5 and that was in 105. That is another line of my argument that when they refer to 11, 1 and 2, the power is to dismiss not to discharge.
What is the difference between two?
Discharge is simpliciter. Discharge is when I can ask for a discharge and they can discharge me that you are no longer required to serve. We are done with it. Dismiss is a penalty. It requires a finding of guilt. Eleven gives them the power to conduct the inquiry, find out the guilt, and terminate my
So
services
when they,
without any
when
further.
they discharge you, you get your,
Only if I am discharged after completing my
so you get your,
qualifying service.
you get your.
In that
full,
case, I get my pension. Or I can be discharged on medical grounds also prior to my qualifying service, and even then the invalid pension
In this
or
case,
the.
you have, in this case, you have served for the qualifying service.
I have served for 16 years as on 2022. So
You
the
get your
other
full,
part,
you get your full pay.
no, the qualifying service will be 20 years.
20 years.
Okay.
Although under CCS pension rules, after 10 years, I can get a proportionate amount of my pension. But since it's a discharge without my pensionary benefits, the pensionary benefits code is not there. Therefore, I would not be entitled to anything.
Okay. Okay, 11. You've seen
11.
that,
Section 11, if we read, my lord, it says dismissal, removal, or reduction by the Director General or by other officers. The Director General, Additional Director General, or any Inspector General may dismiss or remove from service or reduce to a lower grade or rank or ranks the person subject to this act other than an officer. The officer not below the rank of a Deputy Inspector General may dismiss or remove from the service any person under his command other than an officer or subordinate officer of such rank or the ranks as may be prescribed.
গাছি নোট তাত গুচি গ'ল নেকি এইটো ফাইলত গুচি গ'ল নেকি এই নোটৰ এইটো তালৈ গুচি গ'ল নেকি ব্লেংক তাতে গুচি গ'ল নেকি সেইকাৰণে কৈছোঁ আগৰ ফাইলটো এতিয়া চলিব নালাগে আছে এইটো না এইটো নহয় এই ফাইলটো
Page to page.
1470.
1477.
আচ্ছা
Page 1470.
Thank you. Yes, section 11.
Section 11 reads dismissal, removal, or reduction by Director General and by other officers. The Director General, Additional Director General, or any Inspector General may dismiss or remove from service or reduce to a lower grade or rank or the ranks any person subject to this act other than an officer. An officer not below the rank of Deputy Inspector General may dismiss or remove from service any person under his command other than an officer or a subordinate officer of such rank or ranks as may be prescribed. So here the specific power given was one of dismissal. Our division bench has held that recourse to such powers for forwarding entries is not lawful.
But but after this full scene, the the scope of interference of the court in the disciplinary proceedings.
If it was a disciplinary proceeding. If it was a disciplinary proceeding, if it is a disciplinary proceeding, there has to be a charge sheet, an allegation contained by a list of documents and witnesses, a full procedure has to be given, an inquiry report has to come, and thereafter I come inside to say that, yes, I was a delinquent in a particular misconduct. Now here the misconduct is not a particular misconduct. The entire basis of terminating my service or discharging my service is that you have earned 4 reading entries. It is not that you were again found intoxicated. If one more sentence had come in saying that, yes, 4 reading entries and yet you again bought alcohol, even that would be enough. That would be an act of delinquency perhaps. Or that I again presented myself in an alcoholic or an intoxicated condition. But here the only basis is you have 4 reading entries. And the power of discharge not being there for 4 reading entries in the 11-1. 11-1 having a different ambit altogether.
Yes.
I had just given a printout of a judgment, my lord, of Supreme Court, that is 2011-6 GLJ 748, a division bench judgment of this honorable court, Balwant Singh versus Union of India.
Yes.
Now, here, before the 2006 Act came into force, it was the 1941 Act of the Assam Rifles, where provisions were mostly similar, but numbers were later on changed into the 2006 Act. What was section 4 there has now become section 11-1 here. So the context will remain the same if Lordship allows me to read another. Lordship may come from para 6, madam, at page 2. The provisions, so the provisions of section 4 of the Assam Rifles Act 1941, and more particularly subsection 3 of section 4 is read out by Mr. Chaudhary to project that a rifleman cannot be discharged except in accordance with the terms of the statement which he has signed under the AR Act, and specifying the statement in the schedule. The Learned Counsel argues that a discharge under section 4 could not have been ordered against the delinquent on the stated grounds. Referring to 4 specific violations which led to the discharge order, Mr. So-and-so contends that 3 of them related to intoxication and the 4th was of overstaying leave without sufficient cause. He submitted that these violations are not on the heinous category and are not relatable to charges akin to lack of integrity, moral turpitude, or indiscipline jeopardizing the security of the unit. Accordingly, the council contends that the disciplinary authority should not have taken such a drastic view of the act and a lesser punishment could have been inflicted. Mr. So-and-so, CGSC, on the other hand, points out that despite earning raiding entries one after the other, the delinquent did not amend his ways, and therefore to ensure maintenance of discipline in the organization, the authorities had to discharge the delinquent. The Learned Counsel submits that the career record of the delinquent was considered by the authorities, and accordingly provisions was made for payment of pensionary benefits to the petitioner, notwithstanding that what was recorded in the impugned order dated 8/5/2009. The respondents also contend that the petitioner was given a show cause notice before the impugned action was taken when he had pleaded guilty to the charges, and only after complying with the procedure prescribed under clause 5 of the record of instruction, the impugned discharge order was issued by the commanding officer. We have given our anxious consideration to the argument advanced by the rival counsels. The reason is given by the learned single judge for passing the impugned order have also been considered by us. Since the source of the discharge order is under clause 5 of the ROI, the same is extracted herein below for ready reference. 5. Discharge disposal of undesirable inefficient personnel. Right, chapter 8. Rule 24 of the Assam Rifles Manual confers powers on the commandant of Assam Rifles Battalion to discharge any member of the Assam Rifle below the rank of Naib Subedar. This power may be exercised by a commandant in case where a person has got 4 or more raiding entries. In case it is necessary to send an individual on discharge under this provision, a notice will be served on the individual, affording an opportunity to him to explain his case. Thereafter, the complete case will be forwarded to the sector headquarters along with the notice and reply received from the individual for the approval of the sector commander. Thereafter, the documents will be sent to the Director Record Branch for final settlement of his IRLA. This, my lord, the respondents also admit in their affidavit in opposition was followed. This procedure was followed. They had taken my reply.
Where is that 4 reading rule?
Section 11(1), my lord, does not refer to the four reading entries.
There's something
They go to the record of instructions, my lord, which is not a legislative, it was not brought into force by the legislature. It is a record of instructions which they maintain. 4 reading entries, they try to take it away. They go for the job. Because in the 2022 case also, Lordship will notice that it is a record of instructions which they keep repeating to say that 4 reading entries will cause the person, may cause the person. Clause 5 empowers the commandant to discharge Assam.
I have dealt with in some matter. That's why I remember it. So that's why I'm asking whether I took up this matter or not. Because 4 reading, I have dealt with it. There was something that was produced before us. You have anything of the reading? 4 reading?
4 reading order.
Would Lordship take it up on Thursday?
Because if you don't have that on record, and in the proceedings, that earning of 4 entry can be an adverse to that to the petitioner. If that is not there, then the petition has to be allowed.
Yes, after that 3rd reading entry, warning letter was issued to him to don't repeat such type of incident. In my affidavit, that is there.
No,
Yes.
You see, Mr.
Yes,
Mishra's
yes.
argument is that 4 entry, nothing happened.
Yes, nothing happened.
Post 4 entry, there is nothing adverse. And therefore, can the 4 reading principle apply after 2 years to?
No, a notice was, so cause was issued on 2021. Subsequently, yes.
But you are
in the
invoking
reply.
11. But you are invoking 11.
Even after two years, that is the gap is there. 2 years gap is there, and but some judgment I have to search. In the meantime,
Judgment.
No, because then we are bound by the revision bench order of this court. We have to set it aside. 11(1) can't be invoked. Section 11 cannot be invoked for discharge. So therefore, you have to fall back on the reading principle as to how adverse it can be read to the against the petitioner.
after the 4th reading entry on record, yes, we have filed the affidavit on record. Subsequent to that, there is no such incident.
Well, if there's nothing, on record after that, then 4th reading that has been diluted after 2 years. You can't bring that principle and discharge him under 11.
I'm sorry, my lord, it's Rule 108. Regulation 108 of the Assam Rifles Regulation 2016.
Regulation.
Yes, it's 108. Lordship had said 105, it's 108. 108 regulations, my lord, I have that regulation with me. Lordship will have it on Thursday or maybe Tuesday next. And we could take it.
Not this Thursday, we take it up on Tuesday next.
It escaped my notice that 108 had to be gotten. I'm sorry, I'll get it.
No, I dealt with it somewhere, so that's why I have a any idea.
In fact, for another matter, all the Assam Rifle rules, regulations, everything I had put together for another matter in another file. I was just asking, was it not this file that I had put it into?
No, it's okay. It's okay.
108 regulation, it reads, if Lordship allows me, it reads, discharge on ground of raiding entries. A subordinate officer, under officer, or other enrolled person who has incurred 4 or more raiding entries may be recommended for discharge from service on the ground of unsuitability, subject to the following condition. Then, my lord, they have given 5 A, B, C, D, E conditions.
But
They
what
do
is
not-
what is the substantive law by virtue of which this can be invoked and read into the to discharge the petitioner?
That is there, my lord, in Amarendra Kumar Pandey. It has been, everything has been discussed, my lord. That is 2022. Again, any given?
2022.
Yes.
It's 2022. Oh, now I'll have to give the civil appeal number. Civil appeal number 11473 of 2018.
Dated 14/7/22.
Oh,
no?
yes.
14/7/22.
47/2022, and it relied on 2016 2 SCC 6274. It's called
2016. SCC, no?
2016 2 SCC 627. मुझे 2 कॉपी था मेरे पास, बढ़ना भी होगा। एक ये है, ये कौन सा है? ये कौन सा है? हाँ, तो इसका कॉपी कहाँ गया? अभी तो हम हाथ में लिए थे, जस्ट टू बी।
No, but this Amarendra Kumar Pandey, the nature of direction shows that they are perhaps invoking 142 because this is not the this will not be within the power of the High Court to do what the Supreme Court has done here.
Supreme Court,
because here it was the operation of this order was stayed till you attain that till this appellant
yes,
attain the age of pensionable service.
yes.
20 years.
But in this particular case, if the order of discharge is wrong, Lordship will set it aside. It will go to the simple action. Consequences will follow. Here, the Honorable Supreme Court found that if the man is allowed to stay, get a pension, we think that is justice enough. And that justice enough is not what is under Article 226. So Article 226 would only extend to the limit to find out whether it is wrong or right. If it is wrong, it goes. If it is right, it stays.
No, otherwise also,
My lord.
if you don't have the power, why invoke it?
The power under 226 is there to find out whether the order is correct or not. And that extent has to be traversed.
Because then the question of proportionality has to be dealt with.
Because
And
Lordship
then-
will find that this being before the Supreme Court in a civil appeal, something had happened in the division, in the High Court, and orders were passed. Those orders were being assailed. And the Supreme Court, Honorable Supreme Court found that, okay, you let him stay till that part. But that the order was wrong. Hmm?
So that
In fact, my lord,
you see, you please come to page 3 of this order.
my lord.
Having
Yes, sir.
regard to above the court review of the given orders of the discharge, last part of the order in this.
Having regard to the above,
Huh.
this court is of the view that the impugned orders of discharge cannot be sustained. Accordingly, the orders of discharge of the petitions are set aside and quashed. Matter is remanded back to the respondents for a fresh decision in the light of the division bench judgment in Balwant Singh Supra and the discussions made above. Respondents may consider imposition of a lesser punishment on the petitioners, balancing the interests of the organization, also that the petitioners subject to assessment of physical fitness of the petitioners. Read petitioners are allowed to the above action, no costs.
Yes, thereafter came the writ appellate order.
Yes, madam. Which I had placed, madam. No, Balwant Singh order I had placed. So the division bench held. All that is required is to serve a notice on the individual affording an opportunity to explain the provision of clause 5 does not require the commandant to record the reasons of satisfaction for the order of discharge. This was challenged in this civil appeal. Being dissatisfied the inquiry order by the appeal court of the High Court, the appellant hearing.
Therefore, this part of the or this part of the division bench order
My
does
lord.
not even interfere. This is not set aside.
No, that the exact words of such set aside may not have been there, but I think it
So
is there.
therefore, it says merely it says that we stay till you attain the age of superannuation. Therefore, the finding of the division bench is not disturbed.
It is, my lord, it is. It is. There is a sentence, but it may not have been correct.
Let us take it up next week.
Having regard to the nature of the mission, we have the view that the ends of justice will be met if we set aside the order of discharge. The order of discharge was set aside at the end of the
No,
day.
order of discharge was set aside.
My lord.
But the power of the what do you call it? The division bench order is not set aside. The discharge order is set aside and stayed till he attains finality. The principle laid down of this court.
Will come up on the next week, but what I had read from the entire discussions that was held in between the submissions and the analysis part, it has discussed that part of the order, which says that it does not need any reasons or anything, that has been discussed in detail. This Virendra Kumar Dubey Fellowship is para 23.
Because you see, in paragraph 27,
My lord.
it says we may elaborate a little further.
Yes.
Then it goes back and at paragraph 30, it says the doctor may be invoked when there is no reasonable ground for formation of the authority's opinion. Even such a case is permissible.
The doctrine of
therefore-
reasonableness does not when there is no reasonable grounds for formation of the author's opinion. Judicial review in such a case is permissible. When we say that where the circumstance or material or state of affairs does not at all exist to form an opinion, the action based on such opinion can be quashed with the courts, we mean that in effect there is no evidence whatsoever to form or support the opinion. The distinction between insufficiency or inadequacy of evidence and no evidence must of course be borne in mind. A finding
Because
based
now
on
you're now saying,
My
we are just keeping in mind this paragraphs and we are thinking aloud. You see, now you're trying to say that these orders of the division bench or whatever was there. Oh, sorry, I'm sorry. In this case, the 4 red entries were there. And thereafter, after 2 years, they discharged him. But during the, from 2019 to 21, there is no material which can be read adverse to the petitioner. That's your case. But that sort of finding is not here available here.
that when we say the reason to form an opinion that I am incorrigible happens after 2 years of the last 4 reading entry, where is the material to show that I was incorrigible? That incorrigibility, if it had happened, had happened in 2019. And if it was automatic, I would have gone then. Since there has to be some more material to base that decision or come to that conclusion that he remains incorrigible, that the absence of that material is perhaps not what I can argue. Pair 37 is what I had marked out. Pair 37 and 38.
Something is missed somewhere. Paragraph 3. Entry number one is in the year 1996.
Yes, Madam.
Entry two is 1998.
Yes.
Entry three is 1999.
Nine.
Entry four is in 2004.
Four.
But the challenge was made in 2002, paragraph 4. So discharge must have come after third entry. Is that something is
No, Madam, here,
some fact is wrong?
I'll find out the repetition number. This is.
It's
This is
2002.
this is from Guwahati itself.
No, I understand, but it's 2002. That means before the fourth entry.
2004, Madam. 2783. 2783. The number is given wrongly. Lordship will have,
2738 or 2002.
no, Madam, Lordship will have the first page.
Yes.
These appeals were specially directed against the judgment and order passed by Division Bench of the Guwahati High Court in 2017, by which the High Court allowed the appeal filed by the Union of India, thereby setting aside the judgment and order passed by the single judge on 19/1/15 in the repetition. 2783 of 2004.
So that means after third entry, something must have happened. He
No,
was-
no, entry 4 was in 2004. The reading entry last was in 2004 and thereafter he was discharged.
Oh, acha, acha.
This 2002 is a mistake.
Oh, mistake. Oh, okay. Okay.
2002 is a printing
Oh,
mistake.
Okay. Okay.
It's 2004, my lord.
Okay.
And that it is not 2738, it is 2783. At para 4, it should be 2783 of 2004.
Okay. Well, apparently something is wrong.
I also got a bit taken back.
So this is immediately after that.
Immediately. And even then, the Honorable Court, to some extent, tried to see whether there was some material to find his incorrigibility.
Okay.
Here we have a
Take it
gap
up.
of
We'll take it
4
up
years
next week.
between my last entry and my discharge.
2 years.
But 2019 was the last entry.
21 was the.
The show cause notice. 22 is the discharge.
No, but.
So cost in 21.
Show cause notice.
21, yes.
Carried on 21. Okay, we'll take it up. Choose the date.
And I'll bring it more elaborate. Barring 24th, any other day.
Choose the date.
24th, 23rd, 25th,
23rd or 25th.
23rd?
23rd, yes.
Okay. Mr. Arnold Hilbert. As well as Mr. K.K. Parashar of the CEC, present. The learned counsel for both sides that produce the relevant copy of the relevant regulation regarding implication of 4 red ink entries in the service record of the petitioner. So Mazumdar, that will be okay? As agreed to by both sides based on 23/7/2024. We give you back his citations.
In fact, I was giving another citation, which where on which Amarendra
We'll take it
Pandey
on that day.
Amarendra Pandey to this was
There's a reference I'll have to raise. That's right.
May I please, your lordship? My lord, the last item 17.
Let him take a copy because there's a full court reference.
A date, lordship.
Full court will take it.
No.
This is which year?
24. Issue is very simple, lordship.
No, if it is 24, we just roll it over.
Lordship, I am not in interim, without adhering to the national justice, I am discharged from service.
দেখা পাই থাকেন